Upstate Medical University in Syracuse, New York invites you to be the informed patient with the podcast that features experts from Central New York's only academic medical center. I'm your host, Amber Smith. A landmark decision that shapes American patients' rights every day was made 50 years ago in the case of Ann Quinlan. Here with me to tell us more about that case and its enduring impact on our lives today is Robert Olick. He's an Upstate Emeritus Professor of Bioethics and Humanities who specializes in law, ethics, and the physician-patient relationship. Welcome back to The Informed Patient, Dr. Olick.
Thank you, Amber. Good to be with you again.
Now, you wrote an essay about this case. It's appeared in dozens of news sites. I'm anxious to have you tell us about the case and the changes that it put in place. Who was Ann Quinlan?
First, for just a little bit of context, from now to back then, the 50th anniversary of the New Jersey Supreme Court case of Ann Quinlan was March 31st of this year. So to tell the story, we're going back to actually April of 1975, when Ann Quinlan was a young woman in New Jersey who went out to a party with friends, came back, and they found that she had had a cardiac arrest with loss of oxygen to the brain. And she was taken to the emergency room and subsequently admitted to the hospital. And after a period of time, was diagnosed with a persistent vegetative state. What a persistent vegetative state is a condition in which the patient has lost all functions of what's sometimes called the upper brain, the cognitive functions, but still retains some functions of the lower brain, the brainstem. Patients who are in a persistent vegetative state, or the acronym is PVS, a little easier to say, they first off cannot interact in a meaningful way with anyone around them or their environment because their cognitive functions are not there. Patients will require a feeding tube for fluids and nutrition, feeding and hydration. Some PVS patients will need a respirator, but others not. And in Ann Quinlan's case, she needed both the respirator and the feeding tube to continue living. To give a little more context for that, we shouldn't confuse a persistent vegetative state with whole brain death, which is a legal standard of death across the country. The whole brain death standard says that you've lost all functions of the entire brain, including the brainstem, whereas the PVS patient is a living patient because they still have brainstem functions and activity, and therefore decisions have to be made about whether or not to continue the life support for these patients.
Persistent vegetative state, is that the same thing as a coma?
It's not exactly the same as a coma. Both terms have been used over the years to describe patients in more or less this condition, but the key point of difference is the irreversibility of the patient's condition.
So did the doctor and the hospital believe that Ann Quinlan could recover or not?
Not at that time, no, they did not. And most patients, almost all patients who are properly diagnosed in PVS do not recover. Any sort of recovery is extremely rare, according to the experts.
So 50 years ago, in a situation like this, who had the legal authority to make the medical decisions on her behalf?
That's really the key question in the case. What happened was, after a while, a number of months, Joseph Quinlan, who was Karen's father, approached the doctors on the family's behalf and asked that the respirator sustaining her life be removed to allow her to die. They did that on the basis of what they knew about her values and previous statements and wishes, and also what they thought as a family was in her best interest, not to be indefinitely sustained in this unblessed condition that she was in. And the request to the doctors, initially and very briefly, the medical team agreed, but then they quickly changed their mind and said, no, we can't do that. And more precisely to your question, the doctors in the hospital said no, probably for at least the following two reasons. First, that it was a legally unprecedented decision. No case previously had established that patients have the right to refuse life-sustaining treatment and that family members can make those decisions on behalf of incompetent patients who can't decide for themselves. It was also unprecedented in the medical community, although there was evidence and some articles suggesting that some doctors had withdrawn life support from PBS patients. It was not an established standard of care. There was no official statement, for example, from the American Medical Association that you could point to say this is acceptable for doctors to do. In fact, the AMA wouldn't adopt that position until sometime in the next decade in the 1980s. So for that reason, they said no, and that's what led the Quinlans to go to court.
This is Upstate's The Informed Patient podcast. I'm your host, Amber Smith. I'm talking with Dr. Robert Olick, an Upstate Emeritus Professor of Bioethics and Humanities, about the case of Ann Quinlan. What can you tell us about the lawsuit that her family brought?
The case was brought in the trial court in New Jersey, seeking a declaratory judgment that Joseph Quinlan be appointed as guardian for his daughter with authority to direct the doctors to withdraw the respirator that was sustaining her life and to allow her to die. That was the claim. It was based on a number of arguments, predominantly the constitutional right of privacy that existed both under the federal constitution at the time and under the New Jersey state constitution. There were also other arguments about freedom of religion and basically the right of self-determination, but those were the core arguments to discuss for now.
So what were they trying to do?
Well, they were trying to get the judge to agree to appoint Ann Quinlan's father as the guardian with authority to say to the doctors, we want the respirator removed so she can be allowed to die. That was the relief that the Quinlan family was seeking. But unfortunately, they lost the case in the trial court. The trial judge sided with the doctors. The doctors argued first that there was no established standard of care to support a doctor's obligation to comply with the request. And secondly, they argued that it was up to the doctors, simply put, up to the doctors and not the family to decide when it was appropriate, if it was appropriate, to withdraw the respirator from the patient. And as we'll talk about shortly, the New Jersey Supreme Court case that reversed the trial court in favor of the family marks a significant turn from centuries of a medical ethic that doctor knows best, that paternalism reigns, and ushered in the era of patient autonomy, putting patients and families first at the bedside, making these end-of-life decisions.
So this was really a pivotal case.
Absolutely pivotal. It was the first case in this country to recognize these rights. And as I just said, it marks the foundation, the ushering in of an era of patient autonomy that we enjoy today.
Now, the New Jersey Supreme Court ruling was unanimous, right?
Yes, it was.
Does that give it more weight?
Probably in big cases, really important cases that are changing not just law, but eventually it would be changing culture, we like to see a unanimous court. Technically, the legal effect of the decision didn't depend on whether it was unanimous or a majority vote. We know those kind of rules from following the U.S. Supreme Court, as we do these days. But being unanimous gave it more weight in terms of its persuasive authority, not necessarily legally, but more persuasive when all the justices on the court agree.
What were the key parts of their ruling?
The New Jersey Supreme Court case stands for the proposition that we as patients have a right to refuse life-sustaining treatment, that is an important and foundational right, and that when we lose the ability to decide for ourselves, others, in particular family members, may make those decisions on our behalf. Those decisions should be made in accordance with what's called substituted judgment, which translated means that first and foremost, you would look to what the patient herself would want. So you look to prior expressions, statements, values, and so forth. And secondarily, but also very much related, making decisions in the best interests of the patient. So that's the standard by which the decision is made.
We didn't have healthcare proxies 50 years ago, or did we?
Not in the legal sense. There were some pockets of use of living wills, for example, that preceded the Quinlan case. But at the time of Quinlan in 1976, no state had yet enacted an advance directive law that recognizes a person's right to designate, for example, someone to decide for them, known as a proxy or an agent with authority to act on their behalf. The first advance directive law came in 1977 from California, and over the next roughly 15 years, to the early 1990s, every state in the country had done this. So we now have a situation where all 50 states and DC have advance directive laws that allow us to put our wishes in writing, to either designate someone to decide for us or to give more specific instructions about what we would want under certain medical conditions and what treatments we would or wouldn't want, or to put the two of those together in what we could call a combined form, which is usually the most recommended form, and to have those wishes respected, to have those rights respected when we've taken those steps.
Now tell us what happened to Karen Ann Quinlan.
After the New Jersey Supreme Court decision, two things had to happen. Another piece of the opinion was that it had been some time since the doctors had last confirmed her diagnosis and prognosis as being in PBS. So the court directed that they go back and do that again in the form of a prognosis committee, which was also called an ethics committee in the opinion. And that had to be done first. And then the prognosis was confirmed, and the request to remove the respirator was made again. But the doctors, although reluctant, they sort of agreed. But what they actually did was they tried to wean her from the respirator to see if she could breathe on her own. So they would take the respirator away for a little while, put it back, take it away for a longer period of time. And it turned out that Karen Quinlan was able to breathe on her own. And she continued to live in that condition, dependent not on a respirator, but on a feeding tube for the next 9 years until June of 1985 when she died.
Was she in the hospital this whole time, or was she transferred to a nursing home?
She had been transferred to a nursing home.
How do you think a case like this would play out today? Or would there be a case like this?
That's a really important question, and it speaks to the influence of the Quinlan case. What happened in the aftermath of Quinlan was that state after state across the country had their own high-profile cases of patients who were either PBS or terminally ill, and whether or not life support should be withdrawn or withheld from those patients. And the vast majority of states followed the core principles of Quinlan and adopted the view for their states that patients do have the right to refuse life support, and that when patients are unable to make those decisions for themselves in interaction with their doctors, that others, in particular family members, should be allowed to make those decisions on their behalf. So that became the judicial consensus that swept across the country. And that judicial consensus had also established itself over the next, again, roughly 15 years, from 76 to 1990 or thereabouts. And in parallel to that, as we were just talking about, state legislatures adopted laws to recognize advance directives so that patients could put their wishes in writing and answer the critical question, what would the patient want? So we got a consensus that emerged from the courthouse to the state house over the next roughly 15 years. And the legislature was trying to encourage people to answer for themselves more clearly for their loved ones what they would want for themselves.
Have there been any efforts to reverse the current state of the laws about PVS?
Not that I'm aware of. In particular cases, there would possibly be issues about the accuracy of the diagnosis. There are always, from case to case, questions about how reliable the evidence of the patient's wishes are. One of the issues in the court cases was always, well, what do we know about what the patient would want? What did he or she say over time? What were their values? Is that reliable evidence? Does it fit the current circumstances? Those sorts of questions are always there to be asked. I'm not aware of any cases that have denied these rights. There have been occasional cases that might say there just isn't enough evidence. For example, the state of Missouri had a higher burden of proof for families. In New Jersey, the burden was something like, to use legal terms, a preponderance of the evidence or trustworthy evidence. In Missouri, the standard was clear and convincing evidence. And that's the one case that went to the U.S. Supreme Court, which upheld Missouri's right to say you need clear and convincing evidence for this. They didn't find the evidence to be clear and convincing in the courts below, although there were different opinions, both the trial and the appellate court. But when the case went back to Missouri, they did find additional evidence and satisfied the burden. And in parallel was the case of Nancy Beth Cruzan, another young woman who was in a persistent vegetative state. In her case, she didn't need the respirator, but she needed the feeding tube. And her parents, acting on her behalf, wanted the feeding tube withdrawn. And so that was another key difference between New Jersey and Missouri at the time. New Jersey more hospitable to family decision-making, Missouri less so. And in Karen Quinlan's case, the respirator. In Nancy Cruzan's case, it was about the feeding tube. And in fact, the Quinlans never asked that the feeding tube sustaining Karen's condition be removed. And that's actually the reason why she lived for another 9 years after she was weaned from the respirator.
This is Upstate's The Informed Patient podcast. I'm your host, Amber Smith. I'm talking with Dr. Robert Olick, an Upstate Emeritus Professor of Bioethics and Humanities, about the case of Karen Ann Quinlan. I guess I didn't realize that. They never asked for the feeding tube to be removed, only the respirator.
Right.
What's the thinking behind that?
The Quinlans were devout Catholics, and they sought counsel as they struggled with these decisions from their pastor, Father Trapasso, and he advised them that one of the teachings and tenets of the Catholic faith, it's not the only approach, but one prevailing approach among Catholic theologians, is that there's a distinction between extraordinary treatments like respirators and open heart surgery and so forth, and what are considered ordinary treatments, such as a feeding tube. So extraordinary treatments are those that, first of all, involve much more serious intervention, but also come with pain and suffering for the patient and potentially undue burdens. And so it is permissible to withdraw, on this view, extraordinary treatments for those reasons. But ordinary treatments that don't involve excessive burdens, pain, and suffering should not be withdrawn in most cases. And things can change with the patient over time, of course. And along with that, many feel that feeding tubes are akin to basic caring, food and water that is obviously typically given by mouth, and that that's an additional reason to think that feeding tubes should not be withdrawn. And the Quinlans accepted that view, so they never asked for the feeding tube to be removed.
So thinking about the bedside when a patient is in a persistent vegetative state, what do you do as the bioethicist when one of the family members, let's say the spouse or the partner, what they think the patient would want done differs from what, let's say, the parents think the patient would want done?
Mm-hmm.
How do you get those two to merge?
To put it in a little more context, and again, go back to the foundational teaching, so to speak, of the Quinlan case, the other thing, as I mentioned, that Quinlan introduced into this area is the idea of ethics committees. So although in the Quinlan case, the purpose of the ethics committee, or really the prognosis committee, was primarily to confirm the prognosis and then hear the requests repeated from the family and see that there was no disagreement that emerged in the interim, and there wasn't. Ethics committees as multidisciplinary bodies in hospitals began to emerge, and that really took hold around 1992 when the Joint Commission that accredited hospitals at the time adopted a regulation that said all hospitals had to have some mechanism for dealing with ethical issues in patient care. That some mechanism has meant ethics committees, but it has also meant over time the emergence of ethics consultants. So individuals or maybe a team working to get involved in bedside decisions when requested to do so. And disagreements within the family are a common concern, a common reason for calling an ethics consult. It's also the case that the national statistics will show that the majority of ethics consultations involve cases with decisions near the end of life. One thing that's important here is that if you think about the role of the ethics consultant or the ethics committee, there have been maybe a couple of hundred reported cases since 1976 of these decisions and disagreements going to court. But these decisions are made for dying patients to withhold or withdraw life support hundreds of thousands of times a year in hospitals across the country. So while the Quinlan case engendered also some confusion about the role of ethics committees, the role of the committee served what the court thought was a very important salutary purpose of allowing these decisions to be made within the private confines of the doctor-patient-family relationship and not have to run to court every time there's a disagreement.
So, what advice do you have for someone who wants to make sure their wishes will be followed if they're ever incapacitated and wants to avoid a lawsuit and court intervention?
The advice is put it in writing. Every state, again, has a law that allows you to put your wishes in writing and to expect that those wishes will be respected. You should pick someone you trust to act as your proxy, or in New York, they use the term agent. That could be your spouse or an adult child or a trusted friend. Put that in writing, but also talk to them about it. So I had someone ask me the other day, we were talking about these issues, and some people will put it in writing but not talk to anyone about it. They'll just pick their spouse or their child, and then that person gets surprised when the time comes to act in that capacity. It's very important to talk to your family members about what your wishes would be, because even if you try to spell it out in more detail in your document, there may still be a question about how closely what you stated in the document fits the circumstances you're actually in. So best for them to know and also not to be surprised. And by putting your wishes in writing, you are addressing and to some extent relieving the burdens that your family will have in trying to make these decisions. Knowing that they're making a decision that you would want eases their burdens of decision making near the end of life.
This has been very interesting. Dr. Olick, I want to thank you so much for making time for this interview.
Well, thank you very much for having me.
My guest has been Robert Olick, an Upstate Emeritus Professor of Bioethics and Humanities. The Informed Patient is a podcast covering health, science, and medicine, brought to you by Upstate Medical University in Syracuse, New York, and produced by Jim Howe, with sound engineering by Bill Brokel and graphic design by Dan Cameron. Find our archive of previous episodes at upstate.edu/informed. If you enjoyed this episode, please invite a friend to listen. You can also rate and review the Informed Patient podcast on Apple Podcasts, YouTube, or wherever you tune in. This is your host, Amber Smith, thanking you for listening.